So this argument of essentially saying, Judge Hardy, you are biased. So I allowed both sides, you know, if you want to shout, I don't really like doing that.
Calling pages 7 through 23, case number A831379, Nikolai Shaparov versus InfinityLifestyles.com.
Let's state your appearances.
Your Honor, Will Camp, Plaintiffs.
Good morning, Your Honor. Teddy Parker on behalf of the plaintiffs.
Good morning, Your Honor. Eric Pepperman for Plaintiffs.
Good morning, Your Honor. Colt, Dodrill for Nevada Beverage.
Good morning, Your Honor. Bashor on behalf of Nevada Beverage.
Good morning, Your Honor. Jim Cavanaugh with Gordon Reeves for ETT1, DBA Terrible Herbst. Also, my co-counsel, Mr. Dan Polsenberg as well.
Morning, Your Honor. Just barely, actually.
Good morning, Your Honor. Gina Mushmack on behalf of the Real Water defendants.
Good morning, Your Honor. Michael Esposito, 13482 on behalf of the Real Water defendants.
Okay.
Eric Freeman on behalf of Real Water defendants as well.
Oh, good morning.
Good morning.
Nathan Arrington also on behalf of ETT1.
Good morning. All right. So we've got a few things to talk about today. I'd like to start with severance deconsolidation.
Your Honor, I don't mean to interrupt. I think maybe it might streamline some things if we started with the dispositive motions, which, depending on how they go, may render Your Honor's decision on the deconsolidation moot. I've spoken with Mr. Pepperman and he's aligned.
Judge, I'd like to go with the court's inclination.
Okay. Yeah, I mean, there's a number of things, and you know, I went through everything, and we'll go with, for better or worse, the way I want to do it. So there you go.
You're the judge.
I did on these reviewed the plaintiff's position paper and Nevada Beverage Terrible Herbst opposition to that positional paper. As I stated earlier, I had already, you know, reviewed the 3 complaints. So one question off the start, I'd want to hear whether Nevada Beverage and or Terrible's, what their position may be. If I do deconsolidate, am I just going to be back in the same position if Herbst and Soteros are to be potentially consolidated, because that might cut against deconsolidating this right now. Interested in hearing about potential harm or prejudice if I do deconsolidate. Does the issue preclusion issue support deconsolidation? Something I'd be interested in hearing about.
Your Honor, could you repeat that last one again?
Oh, sure. So the numerous, yeah, and I apologize, sometimes I do trail off, so that's my fault. So on the last thing was, you know, the various matters we have on for today. One of them is plaintiff's motion for partial summary judgment on based on issue preclusion. And whether that may or may not support severance or deconsolidation here. I don't want argument right now about the issue preclusion briefing, but if I were inclined to grant that, maybe that would weigh in favor of deconsolidating first from this particular file. So just some issues. As you all know, I've gone back and forth, admittedly, on this issue. I've already talked about how some of the delay, I think it's not necessarily my fault on this, but let's hear first from plaintiff's side on this and then the defense.
I'll be handling this. Okay. And let's start off with why we're here, I spent quite a bit of time, I'm sure my opposing counsel have done the same in preparation for today. And I looked over the scheduling. I want to put things in chronological order first, Sean. This may help in terms of understanding our position on this. The original motion filed by the defendants, the joint motion, was filed on October 23rd, 2025. The two cases, Sotero's case and the Jaster case, were filed on, Sotero's was September 9th, 2025. I'm sure you've seen that now. That motion, the original motion filed by the joint defendants, ET&T, Nevada Beverage, did not mention either case, although they were filed in advance of their motion. And then we filed an opposition on November 7th, 2025. Again, the Terrible case was not mentioned, nor the Jaster case was mentioned because it wasn't mentioned in the motion. And then we get the reply. Again, the reply was not mentioned in the Jaster case or the Sotero case. That was filed on November 10th. So over a month, 2 months later, not mentioned in the motion, not mentioned in the reply. On top of that, Your Honor, we come before Your Honor on November 12th. And on November 12th, towards the end of the hearing, the court said, after hearing all of the arguments, all of the motion practice, and this is starting at line 16, it says, the court is going to deny the motion. That was the motion for deconsolidation and the motion to continue the trial. And the court says, I'm trying to read, I'm trying to figure out how to do it, severance or deconsolidation, or the reversal of the severance suggestion. You said, deny the motion to continue the trial and to deconsolidate for the reasons articulated in the opposition. Of course, that's plaintiff's opposition, which I've rapidly run out of time, because you've been spending quite a bit of time with us. And then you say, but I mean, it was interesting, as you know, the arguments from the briefs were a bit different than the arguments raised here. And I will tell you, the same expression you just had is what I had last night about 11:30 at night. Because I said, why are we here? Given our rules on EDCR rules on motions, oppositions, and replies. And then you said this on page 41. The issues don't have to be identical for consolidation, which is, that's what the law says. There are certainly a lot of overlap, but factually, medically, etc. So denied for those reasons. I've stated, but also the reasons articulated in opposition, there would be harm or prejudice to sever or deconsolidate now. You've not gone back and forth. You indicated what your intentions were. You've given the defendants, despite their failure to follow our rules, over and over and over again, an opportunity to correct their prior mistakes, their prior briefings. What I even found to be tantamount to their continued violation of our local rules is a positional paper sent yesterday that you didn't authorize. This court said, the plaintiff, please provide a positional paper because things were raised outside of briefings. That's what you did in an attempt to provide fairness to what was going on. And instead of that, we have a joint positional paper not authorized by this court, which again really is a means to an end. Everything that the plaintiffs, the defendants have wanted, Your Honor, has been a way to prolong, delay, procrastinate, anything they could do to prevent this trial from going forward. And the reason I say that, Your Honor, and you picked up on it, their brief, the first brief, 22 pages long, 22 pages of that brief, 19 of them are dedicated to continuing trial. The only 2 pages left talked about Rule 42 and consolidation. But again, if you read that portion of the brief, again, it goes back to, we need more time. That would be fair. So we go through that process, Your Honor. You make those comments on November 12th. We come back here a week later because the court said, listen, I want to take a look at the Sotero case. I want to take a look at this, the Jaster case. We come back, and at the next hearing, Your Honor, we have the transcript itself is over 46 pages. The majority of that time is spent with the defendants talking about how much more time they need. And that's what, again, to me, is nothing more than a means to an end. How can we get this trial kicked? And if deconsolidation is the way to do it, that's what we're going to use. And you say during that hearing, Your Honor, the court's position was, I'm going to look over the Soteros or however we'll say it, and Jaster. You were trying to figure out how to pronounce Jaster. And then, this is page 44, lines 12 through 14. I've got to tell you, I'm probably still not going to grant the motion. So, Your Honor, and this is not me being in defense of the court, because the court remembers this once I bring it up. You've not gone back and forth. You've just given them opportunities to be heard. Despite the fact that they have violated the case law on this point. And, Your Honor, we've cited to 2 cases, but there are many, many more. The Hung versus Burhad case in the Nevada Appeals Court 2022, and the Old Aztec Mine case, which is a Nevada case 1981. For the proposition that parties cannot raise new arguments for the first time at a hearing, which they never presented in motion practice, and failure to raise issues in an opening brief results in a waiver. Your Honor, procedurally, we should not be here. Now, I was on the wrong end in another case, Your Honor, where my co-counsel decided to do a motion for summary judgment, then a motion for reconsideration, and then a motion for reconsideration of that. And I happened to be a part of that case. Your Honor.
Was that one in front of me?
That was in front of you.
No. I don't even remember.
And you were adamant that you had never seen a motion for reconsideration of a motion for reconsideration for a motion for summary judgment. And I told you, quite frankly, that I had never seen one. Your Honor, this is what they've done without calling it motions for reconsideration. It was never in their motion. It was never in the reply. It was never in anything until it was thrown out, again, a means to end. Soteros and Jaster has been filed, and all those filed 2 months before we filed this hearing, we didn't decide to bring it up until we were throwing everything we could at the wall to perhaps provoke the court to do something against the rules. And when I say against the rules, against the procedural rules in terms of how they brought the arguments, and against the rules in terms of Rule 42, Your Honor. All of the factors for Rule 42 bode in our favor. We've spent approximately $500,000 getting this case ready. And we're going to spend even more having to do 2 trials. And we would be doing it in a case, if this case was deconsolidated, it would be placing this case in another case that doesn't have similar mechanisms of injury. And you see the plaintiffs, the defendants run away from that issue. They don't address it. What they do address, which has been the arguments throughout, this is the only consistency in their arguments, is we need more time for whatever reason. And Your Honor, your points on that I thought were great. You indicate, and I'll read this into the record. This is Mr. Cavanaugh. As Your Honor is aware, there's a difference between home and office delivery. That was one of the arguments. Your Honor, in the case that you had, the Wren case, we had home delivery and, exactly, we had both. In fact, Shane, please put up on the screen this chart. This is a chart of our discussion in our position paper, Your Honor. I want this court to see. Well, you can't see that, it's kind of small. I apologize.
Dr. Barth, who authored this report.
I don't know who that is.
That was my bad, that was something else.
Oh, okay. Your Honor,
There we go.
there you have it. These are all of the trial cases thus far. Look how they're all mixed in. If you go to the Wren, you got the N's and Y's, home delivery. Go up to the top so you can understand, the court can understand what that is. Alcohol, retail, home delivery. You have them mixed in. All of these cases. So when Mr. Cavanaugh talked about home delivery versus retail, and that's a selfish comment because, of course, and I'm not saying selfish in the wrong way, but it's obvious.
Of course not.
He's talking about retail bottles. We have them mixed in all these cases, Your Honor. When you talk about death versus non-death, the very first case, the Gallagher case, had a death with non-deceased patients. That's not a reason to deconsolidate. When you speak about children versus adults, in your case, Your Honor, we had 22-month-olds and we had 70 plus.
Oh, yeah.
You remember that? Mr. Theodore was in his 70s. And yet we had babies, infants, if you recall. And then Terrible says what is the truth. Mr. Cavanaugh said this. There is absolutely, and this is page 38, there's absolutely no testimony that Mr. Herbst ever purchased real water from Terrible Herbst. Number one. And no testimony when he ever drank real water purchased from Terrible Herbst. Your Honor, you and I have dealt with, over a month trial virtually, consumption. That's in every case. All of these cases, there were consumption issues. That's not a reason for deconsolidation. And then he said, this is page 39, that those were transplant cases. This is a death case. Your Honor, in both the transplant cases, we had people who were non-transplant patients. Again, not a reason to deconsolidate. Nevada Beverage, this is page 41, Ms. Bashor, perfect. She says this is billions in exposure as a reason to deconsolidate. Your Honor, these cases, the first case we asked for $1 billion. We didn't get it, but we asked for it. All of these cases have presented significant exposure.
Yeah, I mean, some of the arguments, you know, I repeat myself, but, you know, some of the arguments on the other side make it, trying to choose my words carefully.
Understood.
You know, so generally speaking, usually you want to emphasize your best arguments up front. Sorry, go ahead.
No, Your Honor, you're correct. You're correct. And you're not repeating yourself. You're actually following the law. And you're actually requesting that people follow our local rules in terms of motion practice. If you want an argument for the court to consider, put it in your briefs. You don't do it ad hoc, impromptu, at the end of a discussion where it's not been briefed at all. That's the reason why you gave plaintiffs the opportunity to do a positional paper. Because this is unfounded. The last positional paper is a rogue document based upon the court's directive. And then Ms. Bashor said, we are being forced to deal with, number one, an expedited timeline with unfinished discovery. Well, Your Honor, discovery is done in this case. Done. We've done over 50 depositions. We've presented over 40 motions in limine. The defendants combined have done over 67 motions in limine. There is no more discovery to do. The only thing I was racking my brain, the only thing I could think of was Dr. Sands is one of our experts who's not been deposed. And then Dr. Filateo was an expert that I think the defendants have that's subject to a motion to strike. And Your Honor, none of them deal with Mr. Herbst. So there's no discovery left remaining to be done that deals with Mr. Herbst. There is no reason medically, there's no reason from discovery point of view that this case should be deconsolidated. And then finally, Ms. Bashor says on page 41, second, with respect to liability, that is not finished. The liability discovery is not finished. Well, that's not true. Liability is done, Your Honor. It's all done. There is not a single thing remaining that would require deconsolidation. Your Honor, we have spent a tremendous amount of time getting this case ready and a tremendous amount of money. One of the other things that I thought was important, and this is a continuation of what the court said. When you indicated that the similarities in this case, when I say this case, the Herbst and the other Shaparov plaintiffs, don't have to be identical. And that's true. But we do have identical mechanisms of injury. They're all, and 3 of the 12 plaintiffs, in this case, Nikolai Shaparov, we call her Ms. K, Lorraine K, and Mr. Herbst, the defendants, experts have said there's a perhaps alcohol causation issue, which makes the defense as well as the plaintiff's position in terms of causation the same. Not supporting deconsolidation, Your Honor. There is nothing that they've presented to this court. And if you look closely at the rogue position paper of the joint defendants, it goes right back to this whole fairness thing and really needing more time. That's the bottom line. I was surprised to see that the defendants would file such a document knowing that the court did not authorize the filing of it. But when you go through it, page 3, it says, plaintiffs move for consolidation on cost savings and convenience to the chemtrail. We've been consistent with that, Your Honor. We've mentioned the prejudice. We've mentioned the harm. The court can see it in terms of the filings. And then they indicate that it'd be extreme, this is page 4, extreme prejudice to ET&T and Nevada Beverage's defense. All of the defense work is done. Where is the prejudice, Your Honor? There is no prejudice that can be will be sustained by the defendants defending the case, given that all the experts have been deposed, all the reports have been prepared, initials and rebuttals, and the motions of limine are done. There is no prejudice that can befall the defendants. And one of the things that you probably noticed in their position paper, because I just know the court reads everything, on page 4, page 5, they cite a lot of California cases. They seem to leave out our EDCRs. They seem to leave out the cases that just actually say that you're supposed to provide your arguments in the briefing and not throw them on the court to have to deal with it during the hearing, which is what happened here. If you remember, they were struggling to figure out what the case numbers were for those cases so the court could actually look them up later, after having not mentioned them in any of the briefings, John. And then if you look at page 5 of their position paper, this is lines 12 through 14. It says, here the rush discovery and accelerated schedule deprive defendants of the opportunity to contest the central issues. How can you say that when your experts have already given initial and rebuttal reports and they've been deposed? Your Honor, there is no factual support for their position paper. There's no procedural mechanisms for what they've done to bring us where we are today. This court, after denying the motion, after further indicating the inclination is to continue with the denial, has given them every opportunity to actually reveal that they've done something by the rules and consistent with our case law here, and they failed on every account. Your Honor, there's no more time that's necessary. Everything's been done, and there's no reason to deconsolidate this case.
Thank you.
Thank you so much.
Good afternoon, Your Honor. Dan Polsenberg for ETT. So there are two things that Teddy says. He says that we're merely looking for more time, and he says $500,000. I mean, I could argue this whole thing based on those 2 points. Are we only looking for more time? Well, yeah, that's what we've been saying all along. We've been saying that we were rushed into this consolidation with cases that are 4 years older to get to a trial date on much too fast a pace.
So if that is your argument, seems to be, doesn't that then necessarily imply or entail, hey judge, and I'm not sure you've actually put this in the briefs, but hey judge, if you deconsolidate, then you also at the same time and or after necessarily has to follow discovery's wide open.
I think it has to be. That's what I'm asking for. Because I think, you know, we're all good at doing proverbs. Poor Benjamin Franklin, we wore him out. You know, it reminds me of the first year I was practicing law. I found this article by Carl Llewellyn, and he said that the statutory canons of construction are like rules of physics. You can find equal and opposite canons for every principle. And here we found, you know, proverbs that are, you know, they have, don't put off till tomorrow what you could do today. We have haste makes waste. You know, I really think, yeah, don't put off till tomorrow, but don't impose a deadline of today in a case where we would normally be allowed to have normal discovery. If we're really looking at Proverbs, I'd look at Proverbs 25:8, which says, don't rush into court. Well, I get it that Solomon was probably looking at some other principles there other than due process. You know, remember, Judge, we got into the Chiavani versus Motor Coach case. And we've been talking about it back and forth. When we were here,
I'll be candid, I don't care about that case, to be perfectly frank, but.
Right, but they distinguished the case 2 weeks ago by saying, yeah, we were on an accelerated schedule for good cause, and then when Mrs. Chiavani, Dr. Chiavani, died, that the defendants never came in and said, okay, the reason for the accelerated schedule is gone, let's have a normal schedule. And so that was a big mistake that those defendants made in that case. And then when things were discovered after trial that didn't come up in discovery because the normal time for doing discovery didn't take place, the Supreme Court was saying, well, you had discovery. So I am not going to make that mistake here. I am going to say, let's have discovery at a normal pace. Done. Done? Done? We're not done here. 2 reasons we're not done. We're still fighting over the documentation for them to prove causation. Isn't that issue still in front of the special master?
Your Honor, can we at least follow rules, one horse run rider on this?
I'm asking for input.
Well,
And I've got 2.
Your Honor, this is not even a positional paper. I mean, how far afield are we going to try?
So,
It is, as a matter of fact, it is. It's got 3 bullet points about the issues in discovery that aren't completed. And so discovery isn't completed here. We're obeying the rules. We're doing all this discovery after the discovery cutoff, so we can try to go to a trial we should not be made to go to. We should do normal discovery. You know, Rex Jemison used to say about, Will and I were talking earlier today about Rex Jemison. So Rex used to say the problem with discovery lawyers is they got a checklist. And they think, okay, we gotta do this, we gotta do this, instead of actually looking for the truth. They're claiming that we are done does not give us the chance to actually get ready for this case. And why are we on this accelerated schedule? $500,000. That's how they argued the motion to consolidate these dissimilar cases. $500,000. Judge, this will be the 6th trial. We don't want to have to try a 7th case. We'll save $500,000 by putting this in with the other cases. There are other cases out there. There is no reason to go on this accelerated course. Mechanisms for injury, well, their argument for consolidation, if mechanism for injury was the only issue, any real water cases could be consolidated. But it still causes injury in these circumstances, Judge. And that's why we are saying that you should deconsolidate. I think severance is a different issue, but they set out the standards for severance.
So I guess, let me ask you, because those two terms, and maybe I'm, overwhelmed by briefs would be my excuse perhaps, but what's the difference between deconsolidation and severance?
So severance applies usually on Rule 14 and Rule 24. For example, it's third-party practice. A sues B, B sues C. Is the lawsuit by B against C so interrelated to the lawsuit against A versus B that it has to be tried at the same time? So certainly here, we wouldn't be in a situation where this case has to be tried with those. And deconsolidation is simply unwinding the consolidation.
Right, that's what we're dealing with.
That's what I think we're dealing with. Now, they raise in their position paper that, well, Judge, it's going to cause more hardship to you because this case is now in front. The Hearst case is now in front of you, and if you were to consolidate this with the other 2 new cases, it would all be in front of you. They just raised that the day before yesterday. I'm not convinced. And when I say I'm not convinced, I mean, yeah, I'm pretty convinced they're wrong. So deconsolidation, you could keep the case, or you could just deconsolidate the case and send it back. So the burden...
Hearst is mine.
Yeah,
Hearst
exactly.
is mine.
That's right.
Only because I don't think it was originally yours.
Your Honor, it was originally Susan Johnson's case, and it got moved to you.
On a peremptory challenge?
Yeah, I believe so.
Then that would be your
So
case.
yeah, Hearst is mine.
Regardless.
All right. So that baffles me that we're going to try this case as part of this case, so that their argument is so that you won't have to have another trial. It's all going back to things that really aren't appropriate to consider under consolidation, or I think under severance, because severance looks at, is it the same transaction or occurrence? And the consumption of real water in Hearst case is not the same transaction or occurrence as the consumption of real water in the other cases, either the existing cases here going to trial or the 2 new cases. So it just causes too much injury without enough benefit, Judge. And let's remember too, a lot of this was started because I'm asking for a stay so I can raise this to the Supreme Court. Now, is that a motion to reconsider? You can make the argument that it was. They have called it, before I did, a motion to reconsider. This court has treated it as a motion to reconsider. And that's why our cases on pages 3 and 4 talk about how if a court does reconsider, then the court has the authority to reconsider, irrespective of what the motion is called. So now you started with 2 questions, but I don't think either one of us answered.
I did.
Well, so...
Issue preclusion?
No, yeah, I didn't address issue preclusion.
I did not address the
but,
third.
one of them was do Nevada Beverage and Terribles, what they, the two of them. This is how I put it in my notes, this is not how I asked it, I think I asked it more neutrally, but in my note, do Nevada Beverage and Terrible stipulate to consolidation of Herbst, Soteros, and the J case?
Yes.
Because if not, then I'm kind of gonna face this issue again anyway. That was more a question for the defense.
Let me discuss things in the audience, and I'll let Nevada Beverage talk.
Yes, Your Honor. So with respect to how we got here, I think Mr. Polsenberg addressed that. Arising from our initial motion to continue and to deconsolidate, we raised a number of issues with respect to the need for more time, issues with respect to bolstering, concerns about prejudice, and the need for deconsolidation, Your Honor. And with respect to the concerns recently raised by the court as to the new wrongful death cases that have been filed, I'd submit to Your Honor that this is not new information, this is not a new argument. If anything, it illustrates and highlights the issues that we have been raised. With respect to the need for deconsolidation as to procedural matters, and for me, I'm a visual person, so when you look at the timeline of events, Your Honor, as to when these complaints were filed, you'll see that as to the initial consolidated plaintiffs, we have first filed was the Shaparov complaint. You can have that.
I mean, I have printed copies of the complaints right here.
Right. Do you have, can you pull that up? Okay. And then next, Your Honor sees in 2021, 4 years ago, beyond 4 years ago, the next one was filed with Martinez, and then the next one filed was Richt. And then not until years later, Your Honor, we have Herbst. And for all of those years, 2021 to 2022 to 2023 to 2024, up until 2025, the plaintiffs have had the opportunity to conduct discovery for 4 years plus. The plaintiffs have time to prepare for trial. They've had time to review the documents, to review the depositions, to consult with their experts, to prepare their experts, and to deal with the timelines that we were imposed. With respect to Herbst, we have had less than a year to do all that. That alone, Your Honor, is prejudice. The procedural posture upon which we have been forced to move forward with trial is irreparable prejudice in and of itself,
So
and that just visually presents that.
Wouldn't, well, I never mind. Go ahead.
Okay. And with respect to the wrongful death examples that were recently raised, those are shown, obviously they were filed just this year as well. So procedurally, they're much closer in time to Herbst than to the plaintiffs that we have been consolidated with. As to Your Honor's question as to our position as to consolidation, on the one hand, I don't think I can say fully what our position would be because we have limited information since we don't have fact sheets and information other than what has been provided by the plaintiffs in their position paper. We have limited information, but based upon the information that has been provided by the plaintiffs in their position paper, Your Honor, I think they set the stage for the fact that all 3 of those wrongful death cases should be tried separately, that they shouldn't be consolidated. And if there is any consolidation, what would potentially make the most sense would be for Herbst to be consolidated with Soteros, if any consolidation were to occur. So, without taking a firm position, Your Honor, based upon the information we're given, that would be where we stand with respect to that. And then as to the issues with respect to the substantive prejudice, again, let's look at, again, the consolidated plaintiffs that we have been forced to move forward to trial with, as well as Herbst. And yes, there has been talk about, well, there's some mixing and matching, but there is such a distinct difference, Your Honor, with respect to a 2016 injury, which is pre-outbreak, like the Cavanaugh case, which was deconsolidated.
Where do you get the 2016 injury question?
He was diagnosed with liver injuries as early as 2016, Your Honor.
So you're not saying in 2016 is when we know for sure he was drinking real water, right? You're saying he was diagnosed with the medical condition in 2016.
Correct, and our position with respect to the real water is we don't know if he was in fact drinking it at all, and if so, when that consumption took place. There's a lot of issues, and Your Honor is familiar that we have filed briefing with respect to spoliation and all those issues. So
there's
that
spoliation motion pending. So
we filed a motion to strike, Your Honor, with respect to spoliation as to those issues.
That one I have not seen yet.
Well, amongst all your other motions. So that, putting that aside, Your Honor, that is our position with respect to that. And then all of these other plaintiffs are dealing with 2020 outbreaks. Home delivery versus retail. Acute injuries versus chronic injuries. Recovered versus a wrongful death. These are very clear distinctions, Your Honor. And while there may have been a mix or matching from prior cases, that should not be dispositive of how this court is going to handle this case with these issues and the prejudice that is to befall Nevada Beverage, who has never tried a case before. We have not had the benefit of, number one, the 4 years of discovery, or trying the case 5 times. So that is important, Your Honor, because they say that, well, you know, you just want more time. But I think it's unfair to downplay that because, and they talk about rules, but our system, our rules, puts justice first. So whatever concerns there are about costs, whatever concerns there are about efficiency, justice is paramount. And I know that this court and everybody here fundamentally wants that. And in this case, Your Honor, based upon the procedural issues, based upon the substantive issues, based upon the prejudice to befall Nevada Beverage, if forced to move forward, that's what we're dealing with. And they want to use, you know, our success, I guess, is in terms of dealing with these deadlines. Essentially, their position would be, well, if you committed malpractice, then maybe you might have an argument. We did the best we could because these were the deadlines we were forced to comply with. So we're doing everything we can, we're working around the clock, and of course we're going to meet the deadlines, take the depositions that we can. There are additional depositions we'd like to take of additional doctors.
Yeah,
we have a motion to
on
compel.
that point, well, I'm sorry, go ahead.
With respect to the motion to compel, that is still pending before the special master, Your Honor. There has been no ruling on that. That also goes towards the fundamental issue of whether there was real water that was consumed. There are thousands of pages of credit card statements that are heavily redacted. We don't have a ruling as to that. So that's impairing our defenses. So, you know, to Mr. Polsenberg's point, based upon this rush pace, we are unable to fully uncover, fully litigate, fully obtain all the necessary information we can. There are some issues that we are precluded forever from having because of the spoliation issues, and then there are other issues we'd like to handle and address but are unable to do so based upon the timeline that we're dealing with. So for all those reasons, Your Honor, we believe that the motion for stay or deconsolidation, which would moot the motion for stay, should be granted.
Excuse me, Your Honor, may I be heard for a brief second?
No, they're both
Well,
terrible.
hold on one second, because,
Can I?
well, look, I appreciate you asking. What attorneys often will do is they will ask and then not wait for an answer. So bear with me just a moment, okay? While I figure out how I want to address your question. And it does take me some time to process this stuff. heard from Mr. Polsenberg, who's your co-counsel, right?
He's the appellate counsel brought in as a co-counsel by formality. I'm the lead attorney for ETT1 DBA Terrible Herbst. I'm the signatory on the positional statement that Mr. Parker was complaining was improperly filed after their position statement. And I always have been the lead attorney for my client. Mr. Polsenberg was brought in to address the deconsolidation as it related to his motion for stay and continuance. I would be judicious with the time I would ask the court to allow me to address it. I'm the one who has briefed these issues. I'm the one best in position to respond to the remarks here, and I can assure you it will be informative to the court if I'm allowed to do that in a very objective way that will help the court perhaps weigh the matter for him.
So I think the answer to my question is yes, but I'm not sure. Yes? Yes, he is your co-counsel?
He is, I'm sorry, Your Honor, he filed a,
my question was pretty simple.
He is
I think he's
officially,
your co-counsel, but if he's not, just say no or yes.
I'm sorry, Your Honor, he is officially a co-counsel. He's appeared for our client.
Okay.
Yes, yes.
Okay. I mean, that was my, sometimes it takes me a moment or two or three to formulate a question, but that was my question. He's your co-counsel. Okay. Ms. Bashor is counsel for one of the other defendants, yes?
Correct, in Nevada Beverage.
Okay, okay. So I'll leave it to you to choose this way, I suppose. Yeah, I'm going, I don't want, I'm allowing a lot of opportunities that I don't normally allow, let me put it that way. But, so here's your choice. Happy to hear from you, but if that is the case, then I'm gonna hear from plaintiffs after you.
Understood.
Okay.
And I appreciate the opportunity, Your Honor.
Okay.
First, I want to just clear up the record that I thought was most appropriate was the last time we were before Your Honor on the 24th. And your comments that day were very helpful, I thought, to everyone. You talked about how you arrived at your decision to consolidate, and you reviewed a number of good reasons that underlie, that were the basis for your decision. And you enumerated them in the record on the 24th. There weren't a lot of surprises expected. There have been 5 trials before on the real water cases. The substantive product, the substantive document production you had thought in the thousands had already occurred. There were prior trials. A 7th trial was to be avoided if it could and efficient and for the reasons that everybody recognized. You mentioned you thought there were 5 depositions to be done. That there was, that the only issue you felt the defense had raised was a lack of time to complete discovery, and so you continued the trial as plaintiff agreed to till January from its October date. And that's what was before the court at that time, and you reviewed that. However, the court also pointed out you've since become aware of 2 other wrongful death cases, cases that were similar in damages to the Herbst matter, unsimilar to the damage claims in the Shaparov other 9 plaintiffs matter. You also pointed out you now, besides the wrongful death cases that you've now become aware of, that these cases now were only on the retail bottles versus what was home office delivery in the Shaparov matter. You also pointed out that there were new retail defendants, in addition to the current defendants in the Herbst matter, retail and distributor, that weren't in the Shaparov case. And you said you had given it a lot of thought, and Your Honor, focused us all on the fact that those were the key issues, and that all along those were what you find to be most important. And it's very true. A lot of people didn't know, I'm including plaintiff in that 2 months after the consolidation case, they were going to have 2 new wrongful death cases a couple of months. They probably had no idea that was in the pipeline. I don't know. Sure. But it sure, there wasn't any need for anybody to show that kind of candor to the court to tell them about it, apparently, to tell Your Honor that was coming. And the comments that it was costing them $500,000, $490,000, there was an exact dollar figure in the moving paper as to what could be avoided by this consolidation. Your Honor, let me just cut to the chase. There is discovery ongoing. Mr. Polsenberg pointed out there's an ongoing major discovery dispute over document production. We've produced 35,137 documents. I don't think Mr. Polsenberg knew the number. Plaintiffs claim we should produce more, another 200 and something thousand documents. Documents that were subject to a clawback order, they stipulated to, and Judge Williams signed. And I think we'll prevail on that. But what maybe my friend, and I do consider Mr. Parker my friend, what he's completely wrong about and what he has mistakenly misinformed the court on, its discovery is not done. I'm holding in my hand a document I'm happy to show the court that is a response to written interrogatories we served on plaintiff. Responses were due the last day of discovery, the cutoff, November 19. I was asked for an extension of 1 day and I granted it. This document was filed in the system, e-filed by plaintiff's counsel on November 20th, the day after discovery closed, formally the date it closed, but we've been going on with, we've had multiple expert depositions since that day, multiple recipient witnesses. My client's president is scheduled for a deposition next Monday. That discovery is not done. But what's informative to the court about the document I'm holding, and plaintiff's responses to interrogatories, which very simply ask, tell us all your evidence of documentation of Mr. Herbst's purchases from my client, Terrible Herbst. Tell us the dates that happened. Tell us who is a witness to him even consuming real water. Him even consuming real water that was purchased from Terrible Herbst. And the same answer is given, there are 15 interrogatories here, and they're all not the same interrogatories, but the answers are all the same. But what's particularly informative to the court with regard to the comments being made, discovery is completed. The last line is in a separate paragraph, after they don't answer any of the questions asked about Mr. Herbst's consumption of real water, or what's their proof they got it from Terrible Herbst, or that he ever purchased it at any particular time. The last thing they say, Your Honor, and I checked it all 15 times, I quote, this is on November 20th. Discovery is ongoing, period. Close quote. That's their response in all 15 to my interrogatory, simply asking for proof, as they're forcing us into a trial in January, of what's their proof they even bought the product from my client. What's their proof they ever consumed a product sold by my client? And they've given none of that to us. And he's told you today, discovery is completed, they're done. I could quote that to you, but it's in the record. Somebody's not being square with the court. Now, we're allegedly violating some procedural rule, The court has complete discretion to reconsider its own orders and rulings within the framework of this particular matter and this issue. But I would like to exhibit this as Exhibit 1 to the fact that discovery is not completed. Plaintiffs are saying so in documents they're serving after discovery is closed even, that discovery is ongoing. Maybe you didn't maybe they forgot about that. He is my friend, and I don't attribute any intentional misconduct to him, but this court has to be aware. We have not had a chance to complete discovery. And the reasons the court decided to reconsider the deconsolidation issues are well known to the court. New retail products, new defendants, retail defendants, distributors that weren't in the Hearst, that weren't in Shaparov, are in Hearst, they're in Soteros, and they're apparently in Jastra. We are defendants in the Sotero, we being ETT1. We're not a defendant in Jastra at this point anyway. Your Honor, I have more to say, and I apologize if I've taken too much of your time today, but I'd be happy to answer any questions. I would like, with the court's indulgence, to present this to the court as Exhibit 1 to our opposition to the position papers that plaintiff filed. Hold on. This being plaintiff's, Sarah, there's two daughters, I'm sorry. Did you want to say something I should let you know?
I thought I was going to respond to what you just asked that I do.
Okay. I was just going to describe it for you, that's all right. Sorry.
At the risk of asking you a question or two more, what you have in your hand there is dated November 20th, is that right?
Yes, Your Honor. Filed electronically November 20th.
Do I already have that in the
I'm
numbers?
sorry, not filed. I misspoke. Served.
Served, that's fine.
Served. You do not have it, Your Honor.
So, you cannot, to answer your question, can you present that to me as Exhibit 1 or whatever right now? The answer is no. As I will often tell various people, this is not Perry Mason, it's not Matlock, I date myself, but, you know, this is not, especially here, where I've allowed briefing to go far astray of what's normally done. I've allowed arguments to go far away of what's normally done. And now you're saying, despite how many ever inches of paper I already have on all of this, here's the thing that was served on November 20th, and despite us even doing, us meaning defendants, plural, opposition to plaintiff's positional paper in support of deconsolidation on December 2nd, here's something, so to answer your question, the answer is no, but thank you for asking.
Can I ask another question?
Oh boy.
Pardon me?
I said, oh boy.
You
You can ask, I'm not sure I'll answer.
Fair enough. How does my asking to show the court a document plaintiff served, a legal document that they're bound to, that I just described as their responses to, how does that differ from counsel showing you something on a video screen that wasn't part of any pleading or paper and refers to 5 other cases that have nothing to do directly with this case that we're here before the court on? So I appreciate you let me explain why I thought this would be an appropriate thing to show the court. If I'd have had it on the video screen, I guess I might have had a better chance.
was a lot to unpack there. Much of which was not a question, much of which was argument. So you all remind me when we have the hearings on your motions in limine that I definitely need a timer. And I definitely need, just hearing from one person, otherwise, we're gonna be here days on end, in arguments. So I allowed both sides, you know, if you want to shout, I don't really like doing that, but when people shout at me, it's not. I'm trying not to respond in kind, let me put it that way. I allowed both sides, both plaintiffs and defendants, to put essentially what are demonstrative exhibits up on these screens. So this argument of essentially saying, Judge Hardy, you are biased against defendants and in favor of plaintiff because you allowed plaintiffs to put something up on the screen and you will not allow me to mark a document that I did not attach to my joint defendant's opposition is not well taken. So that's the answer to your question. You chose the option to argue, which is fine. I appreciate arguments, but now it's plaintiff's turn to argue.
Thank you, Ron.
Your Honor, thank you for being patient. I was taken aback by my friend's comments. You probably saw me duck my head down when his question was presented in the form of argument. Again, the court has given the defendants a mile's worth of patience to introduce documents not authorized, to argue points not in briefs. And everything that was just said by my friend, Mr. Cavanaugh, you've heard before. Everything argued by Mr. Polsenberg, who's also a friend of mine, you've heard before. Your Honor, looking at the transcript from...
And Ms. Bashor, don't forget.
Oh, I apologize. Ms. Bashor's a new friend. I have not known her as long, Your Honor. But a new friend.
We're old friends.
Dan and I go back to the beginning. And so, Your Honor, you've heard it all. And I'm going to remind the court, because this is something I have not read into the record yet. I didn't think I would have to read it into the record because I didn't expect them to argue the same things, because that's not what the positional paper was meant to do. Your Honor, the transcript of November 17, this is page 34, and I want to put it in further context, because you knew this, but you didn't know the numbers. But I'm going to give you the numbers. You indicate, this is after Mr. Polsenberg had spoken and after Mr. Cavanaugh had spoken. This is line 19. And this is the court. So some pushback on that, though. You know, as detailed in plaintiff's opposition, this case, these cases, plural, really, it's not like your clients coming in brand new. In the context, Your Honor, Nevada Beverage, while not a part of the trials, have been a part of 4 cases. Terrible Herbst have been a part of 4 cases. You knew, but you didn't know the numbers. You further say, There have been multiple other cases with all sorts of discovery, all sorts of trials. So how does this not play into the plaintiff's favor in terms of, you know, unlike Kiabani, which I didn't even present during my argument this morning, Your Honor, which is assumed was like some one-off normal kind of case. Here, even though your client may not have gone to trial or fully gone to trial, because you recognize that Terrible was a part of the second trial and then several during trial, it's aware of numerous of these issues and experts and all that. Doesn't that favor the plaintiffs? You heard everything they said. Considered all their remarks, which has been regurgitated for you again at nauseam, at length, Your Honor. And that was your opinion then. That was the court's inclination there. Then, nothing has changed, Your Honor, except that we've completed all the discovery in terms of the expert depositions. I struggle to try to reconcile what Mr. Cavanaugh said about remaining discovery. You've said this before in the Wren case. If you have discovery issues, you have a special master. How does that come into play on a deconsolidation motion, Your Honor? That's not one of the issues. Your Honor, any discovery issues that Mr. Cavanaugh is speaking of, those should be in front of the Discovery Commissioner. If they rise to the level of coming to your court, they can address it to the court. But it doesn't change the mechanism of injury. It doesn't change the fact that they would add another trial to your docket if the deconsolidation was granted. And it doesn't change everything this court has said in the prior two hearings. Your decision to deny the motion, your decision and inclination to continue denying it, but you would look at the Sotero's cases. We've now provided you the Jaster case is an ALS case, different mechanism of injury. The Sotero case, no alcohol involved, unlike this one, where we have multiple plaintiffs with alcohol issues, where the experts for both sides have discussed it, and they're all prepared. Your Honor, I have not heard, and hopefully the court has not heard, anything that should change the court's position on this. The two questions you asked, Your Honor, the first one was Nevada Beverage and Terrible, as to them in terms of deconsolidation. Your Honor, we have 5 other defendants that will be brought into the cases for the Jaster case and the Sotero case that are not a part of this case. They didn't even mention that to you, Your Honor. Your second question was the harm and prejudice to plaintiffs. We said the amounts. I said that early on. But you're also looking at the discovery difference. We've not started discovery in any of those cases. When I said earlier the means to the end, Your Honor, you picked up on it, and then they played right into it. Ms. Bashor talked about she needs a trial continuous because it's not fair. Justice doesn't allow for her to go and be ready. That's belied by what we've done up to now to be ready for this trial, Your Honor. Mr. Polsenberg, true to form, said, I needed to stay. That's what I asked for, and that's what I'm trying to get. Be it by deconsolidation, by discovery continuance, or trial continuance. I respect that. But he has a mechanism. If you deny the stay, which you've already indicated, he can go to the Supreme Court and see if he can get the stay. Again, that does not require deconsolidation. Your Honor, you've made the right decision. Your inclination is correct. And there's been nothing presented to you new that supports changing your mind. Nothing. Everything they've said now is played out in those two transcripts that I've read to you, Your Honor. And one thing they can't say is that I've misquoted you. And so, Your Honor, I again appreciate the patience. The only other thing I would say, and this is something that Mr. Kemp and Mr. Pepperman reminded me of, AT&T and Nevada Beverage, they knew all the liability issues before this case got going. In terms of discovery, they had 2 law firms working on with a lot more resources than the 3 of us, you can tell by just the numbers, to do research on the medical condition of one person. One. And yet they believe that prompts all this additional time. It doesn't make sense, Sean. We've had to do it on all of the plaintiffs within the same time. And finally, Your Honor, most of the expert reports that we had on liability, they're the same as the other cases. They didn't change. So, Your Honor, unless I missed one of your questions, and if I did, I apologize, I'm more than happy to answer it. I believe those were the questions you asked. Oh, the other one was various matters for today and how the plaintiff's MSJ on issue preclusion supports deconsolidation. I think that was the last question, Your Honor. Given what we've done in the prior cases as a benchmark, Your Honor, you've ruled on that motion before. I think this streamlines this case. I think that denying their motion for deconsolidation and handling the motion however you choose to handle the motion for summary judgment would only probably benefit this case. Because you're taking a known one trial in front of you now, as opposed to adding additional trial because the first case would still be in front of you. So I think everything we've looked at, every consideration that's afforded under the case law interpreting 42, NRCP 42, supports denying the motion. And if there's anything else, I'm happy to answer.
Nothing else, thank you.
Thank you, Your Honor.
Everybody available to come back at 2 o'clock.
Yes, Your Honor. I'm going to answer on behalf of the whole plaintiff group, Your Honor.
You're the judge, Judge.
No, I think you're good.
See you.
Thank you, Your Honor.
Thank you, Your Honor.
Court denies the defendant's motion to stay. The court denies defendant's motion to continue and extend discovery and be consolidated or to reconsider. As to both, there's no good cause shown under the totality of the circumstances, including but not limited to the arguments raised by plaintiffs in opposition, any of one of which by itself is sufficient reason for denial. As to the motion to deconsolidate and or to reconsider and or to extend in particular, the consolidation one that continues to be proper under NRCP 42A for all the reasons I've already articulated on the record more than one time. The cases certainly do involve multiple common questions of law and fact. Defendants have had sufficient time under the totality of circumstances to conduct discovery. Trial was already continued one time, I would point out as well. There's no undue harm or prejudice to defendants. There would be to grant the deconsolidation. There would certainly be harm or prejudice to Plaintiff Herbst. It's also worth pointing out, and I know I've said this before, but you know, not once in the October 23rd, 2025 motion, nor in the November 10, 2025 reply did defendants mention either the Soteros or Jasper cases. Defendants have also been part of multiple prior real water cases, at least throughout discovery. Plaintiffs, if you'll prepare 2 orders, submit them for review and approval to defendants.
Will do, Your Honor. Thank you so much.
Thank you, Your Honor.
Thank you. Without argument, the court rules on and denies plaintiff's motion to strike defendant or Rules on denies plaintiff's motion to strike defendant's counter motion is improper under EDCR 2.20. Okay, let's get to some substance. The next one, and you know, kind of going back to how we began today, you know, I try and do things for reasons, and in this case, you know, certain of these motions and in order. The next one that I'd like to have argument on, plaintiff's motion for partial summary judgment based on doctrine of issue preclusion. So I've reviewed that, the errata of the appendix to that, DTT, Terrible Herbst, response in opposition, counter motion for summary judgment, exhibits to that, the real waters opposition, joiners, multiple briefs. I think on the plaintiff's motion for partial summary judgment on issue preclusion, candidly, I think one of the more important things involving that is Judge Kishner's order. That was filed January 17, 2024. We are going to have to time you all today, this afternoon. So you've got an hour overall each. See if we can get through things. On plaintiff's motion for partial summary judgment and counter motions. They're first from plaintiffs and from defendant and defendant. If you want to argue separately, that's fine. I'm not going to have tag team. So one attorney for each party. I know there's more than one party, but we're not doing tag teaming like we did this morning. So let's hear plaintiff's motion and counter motions on doctrine of issue preclusion.
Thank you, Your Honor, and I think, you know, to try to be considerate of the court's time, who you've already been so gracious with already today, I would start by asking if there are any particular questions with this motion that the court has that you would like me to address at the outset.
Well, part of why I said I think Kishner's order is one of the more, if not the most important thing for me to consider here is, I believe at that time, so made this kind of a question, or correct me if I'm wrong, that not just Real Water was a party to that, one of the other defendants, I believe, was a party to that. Is that fair?
That is correct, Your Honor.
So which one was it? Remind me which one.
Terrible Herbst.
Okay.
Nevada Beverage was also part of that case, but they had settled prior to the summary judgment.
That was probably my only question.
Okay, Your Honor, and I think that is a very astute observation. That was going to be the start of my argument to begin with, because there was a lot of argument about the stipulations and admissions. that I wanted to clear up. And one thing I want to be clear about is what we're asking for in this motion and what we're not.
And that, yeah, that's a good point. Go ahead.
So what we are asking for is a narrow ruling granting partial summary judgment as to liability only, not causation. We are not asking for the court to determine causation under this summary judgment order. We agree that it's a different party, and causation is not, it's something different. We're not trying to prevent them from disputing causation or filing motions on causation. Those are separate issues that I think are going to be handled either later today or down the road as
So
well.
even as to liability, attorneys will often make that distinction as you're doing right now, and you kind of did in your briefs. And to me, that's somewhat amorphous, because you know, like, let's say just a typical negligence case, you know, duty, breach, causation, damages. So what's liability in that? Is it duty and breach? Is it duty, breach, damages? And I think you all may be, although you all say liability, I think, and you all plaintiffs, I think, you also say even a more narrow version of liability. Is that fair to characterize that?
Your Honor, you're reading my mind today, because that is exactly where I was going to go next. So when we talk about a strict product liability claim, essentially there's three elements. Defect, the product was defective, the defect existed when it left the defendant's hands, and the defect caused, was the legal cause or substantial factor in bringing about the injuries alleged. So what I'm referring to are really the first two, defect and defect existed when it left the defendant's hands. And they're really combined into one. There's no real dispute that the hydrazine, assuming it's in the bottles, which is what the judgment by Judge Kishner is and what the evidence was that resulted in that order, there's no dispute that, oh, well, okay, maybe the hydrazine was there, but it got in there somewhere else in the chain of distribution. That's not an issue. So what I'm really referring to are those two elements, but for all intents and purposes, it's defect. It's that hydrazine was in the water. And that's, when you look at Judge Kishner's summary judgment ruling, that's what she expounds on and what she rules upon based on the evidence and the facts and the arguments in that case. And again, she addressed this issue. You kind of brought it up about in the deconsolidation issue as well. You know, if I grant summary judgment based on issue preclusion, what does that do? She addressed that issue with, well, you have a manufacturer, and the manufacturer is, you know, saying, we agree, there's hydrazine in our product, there was hydrazine in our product. How does that apply to the downstream distributors and sellers of the product? And we litigated that issue and briefed it and said, well, look, I mean, they just take it from the manufacturer, and if the manufacturer is saying there's a defect or there's the evidence, then they're bound by it. Judge Kishner said, well, yeah, she actually asked for further briefing on that, and that was an issue, and but she didn't even really decide it that way. She looked at it from an evidentiary standpoint and said, okay, Terrible Herbst, you say you don't want to be bound by this evidence in the manufacturer. Show me the evidence that supports there not being hydrazine in the water at any time. Show me what evidence you would present. And they couldn't, because there is none, because if you look from the top down, FDA, every sample of the concentrate they used to make real water, they found hydrazine when they tested.
Regardless of whether it's the gallon drums, or I forget the term you all use.
5-gallon jugs or the retail
Jugs,
bottles.
yes.
Yes, Your Honor.
5-gallon jugs or the retail bottles, the process was all the same, right?
That is correct, Your Honor. And in fact, if you recall, UNFW, one of the distributors in the other cases, this was their theory at the outset, was, oh, it's the 5-gallon jugs. So they took some retail bottles that they had stored in their facility that were 2 years old, and I thought they thought that probably enough time had gone by that they were going to prove it's not in the retail bottles. And we know that was a spectacular backfire, because they sent it out to Eurofins, and Eurofins found hydrazine in we say all 7 bottles. 5 of them were above the detectable limit, guaranteed hydrazine in those bottles. The other 2, there wasn't hydrazine at the reportable limit, but there was evidence from the testing that suggested that there was some trace amounts of hydrazine in there. I want to just address at the outset on that testing, because the defendants always try to misinterpret it. That is not a quantitative evidence of the amount of hydrazine that you're going to find in these retail bottles at the time they're consumed. These bottles were sitting in a warehouse in a storage facility in a hot place in Fresno for years after manufacture, before they were ever tested. So it's really a qualitative evidence. The fact that there was any hydrazine in these bottles still at that time is amazing. That shows you how much hydrazine was in the bottles at the time of consumption. And so they always try to misrepresent the amounts and say, oh, you're going to get sick off these amounts. Well, those aren't the amounts that people were consuming. It's just a qualitative piece of evidence that is conclusive proof that hydrazine's in the concentrate that they use to make all the water, 5 gallons, retail bottles, and then you test the retail bottles and you have the hydrazine in the retail bottles.
One of the arguments that defendants make, at least to some of the plaintiffs, if not all of the plaintiffs, is that, it's that there's no evidence that plaintiff, let's take decedent Mr. Herbst, there's no evidence that he drank the water, I think is what they say. Would granting your partial summary judgment preclude that argument and evidence at trial?
No, Your Honor. That is a causation question. Suffice it to say, I strongly disagree with their characterization of the evidence.
I knew you were going to say
Mr.
Don't worry about
Herbst
that.
not drinking water. But, that's a question for a later motion, or if there are questions of fact, then it's a question of fact for trial. And obviously, if the jury concludes, as we believe the jury will and should conclude, that there was substantial evidence that he was drinking real water, then all this summary judgment does is establish that the real water he was drinking contained hydrazine, which is consistent with the summary judgment ruling by Judge Kishner. It's consistent with the multiple stipulations, the admissions, and the evidence that overwhelmingly shows that this water was tested, was found in the product. We presented evidence from the experts how the hydrazine was being introduced into the concentrate. That has never been rebutted. There's no alternative theory stated by any expert to a reasonable degree of scientific certainty that, you know, real water got into this concentrate in some other way than through the titanium tubes, the electrolysis process in the titanium tubes, which real water is repeatedly over and over and over again admitted and acknowledged. And the binding 30v6 testimony of Blaine Jones, who was their representative on the manufacturing process, who says from the get-go, from the start to the finish, when they finally discovered the hydrazine in the water, and tested and proved by the FDA, they followed the same manufacturing process, the same titanium tubes, the same general ingredients, the same general process. The water was always made the same. There is no evidence to suggest that this process was making hydrazine in the concentrate at some point in time and not in the others. There's just no evidence. And that's exactly what Judge Kishner found in her order granting summary judgment, that we met our burden of establishing proof that real water was defective, that hydrazine was being introduced in the electrolysis process. It was the same way. It was all bottles, anyone consumed, including the plaintiffs before her in that case, and that defendants did not rebut that evidence to create a genuine issue of fact at trial because they identified nothing. They had no alternative explanation for the hydrazine. They had no reason to say why it wouldn't be in the water, you know, in 2010 and it would be in 2020. There's no evidence to explain that.
Sorry. So yes, real water certainly is and yes, Terrible Herbst. I have no reason to doubt you. We'll see what the opposition says, but both those things subject to Judge Kishner's order. Tell me about against Nevada Beverage.
Well, it's the same thing with Terrible Herbst. It's the same evidence. They have the same evidence then as they do in this case. The same evidence was before Judge Kishner. And when you look at issue preclusion, is the issue in this case identical to the issues decided? Yes, same exact issue. Was the prior issues decided on the merits and result in a judgment, final judgment? Yes. Judge, this, you know, and that kind of takes them out of the whole stipulation argument. And Judge Williams entered summary judgment for the same reasons in two separate cases as well. So it was some stipulation, some summary judgment orders by multiple judges. And that is a summary judgment order, is a final judgment for purposes of issue preclusion. And if the issue actually and necessarily litigated, yes, issues, same issue, it was litigated, we did discovery, we presented evidence, they made their arguments, we made our arguments, and the issue was litigated and decided. The last element is the prior real water matters decided on the merits and resulted, the party against whom the judgment is entered is the same party or privity. The other one. And so in the worst case scenario, this order would not apply to Nevada Beverage. In which case, we have a separate summary judgment motion on this issue based on the evidence that we filed before. That's going to be heard as part of the pretrial motions.
Okay, so that one's pending.
It is pending.
Okay.
So I would submit that if Nevada Beverage is a party already in privity, considering they're just in the chain of distribution, but really, that's, you know, if the court is more comfortable handling this issue on Nevada Beverage as part of the later motions, I don't think that's a big deal. I would at least ask that summary judgment as to issue preclusion be entered against Real Water and Terrible Herbst based on Judge Kitchener's summary judgment order. And unless the court has any other questions, I will